Before we get started in this episode, a quick announcement. As you know, I'm very passionate about acceptance and commitment therapy, and I also run a busy practice in Canberra. We're currently looking for psychologists who are registered in Australia to join our team, who are also passionate about learning about ACT. We provide supervision on a group and individual basis and training around ACT. So if this is you, if you're interested, please express your interest at strategicpsychology.com.au/careers. Look forward to hearing from you. And now back to this episode.
Okay, life can be crazy. You're feeling like you're sinking, just trying to find a meaning. It's time for better thinking. Yeah, better thinking. Time to tune in. Let's go.
Welcome back to Better Thinking. My name is Nesh Nikolic, and my guest today is Professor Blake McKimmie, who is an Associate Dean Academic in the Faculty of Health and Behavioural Sciences at the University of Queensland. Blake won a Faculty Teaching Excellence Award in 2010 and a University of Queensland Teaching Excellence Award in 2016. He led a team that won the AAUT Higher Education Teacher of the Year Award in 2019 and received the edX Prize in 2018. He currently teaches a large introductory psychology course and a second-year elective about psychology and law. His research focuses on jury decision-making, including the influence of gender-based stereotypes and the influence of different modes of evidence presentation. He's also interested in group membership and attitude behavior relations and how group members influence thinking about the self. He is a lead instructor in the award-winning course Crime 101X and the PSYC1030x Introduction to Developmental, Social and Clinical Psychology XSeries Program on 4 courses on edX.org. Today is a really interesting conversation that I'll have with Blake about this idea of understanding biases that occur in courtrooms with jurors in particular, how the architecture can go out and add to these biases or differences in the way that we perceive the court proceedings as jurors, and also how evidence is presented and how that can also have an effect. Lots of topics discussed here. Blake really knows this space exceptionally well, and it was an absolute honour to have him as part of the podcast and teaching myself and hopefully yourself through this conversation. What are the stereotypes, the biases, the heuristics, and other influences that we are subject to as human beings, and one day possibly as even jurors. I hope you enjoy this episode. Blake, a big thank you for coming onto the show today. I'm really excited to talk about a real interest piece for me, because it really, to me, is an exemplar of human biases and how we can learn from these and appreciate ourselves and others in a way that we maybe haven't considered before. So excited to talk about jury decision-making, influence of based stereotypes, and, potentially even the influence of different modes of evidence presentation. So thank you for coming on to the show.
Thanks for having me, Nesh.
Look, I'm not really sure where to start with this, because there's a lot in there, but maybe if I open up to you about how you got into this space, and then maybe lead from there as to, how we look at these, whether it's the jury decision-making or the, presenting evidence, gender biases, how they play in, because I'm sure that all is a big part of the legal world, and probably also feeds into how we also do life in different ways.
Yeah, so it's a bit of a circuitous route into the topic. I actually started off at university studying law, psychology, and computer science. And sort of what happened is, after a few years, I had to decide whether to continue on with my psychology or finish my law degree. And I actually ended up continuing on with psychology, never quite got back to the law degree. So I've kind of always had a bit of an interest in both of those areas, and could sort of see how they intersected. And when I started my PhD, which was in social psychology, we had a visiting researcher from Canada and she was interested in expert testimony and gender stereotypes around expert testimony. And so I started working with her, and pretty much ever since then, I've just continued working in the area of trying to understand what are the sorts of things that might influence jurors and how they make decisions, from the whole sort of perspective of decision making by jurors. And more recently, we've kind of extended that to look at how investigators and police are influenced by the same sorts of stereotypes. And it's just part of that big picture of looking, where is it along the decision-making processes? Because there's lots of different levels in the criminal justice system where quite important consequential decisions are made. It's not just at the trial, but it's also at the investigation stage and decisions about prosecution. And then, what happens in the jury room as well. And, because all of those people are humans, they're influenced by the same sorts of stereotypes and cognitive biases in decision-making. So that's kind of how I got into it. But I think, one thing I'd say to sort of preface all the comments I'll make today is, my interest in understanding the sorts of things that influence jurors is not about sort of pointing out how bad juries are or jurors are. They're just people, just like anyone else. And it's really about, what is it that we could do that might help jurors make decisions. And some of those things are sort of structural systems with the justice system. Some of them are to do with cognitive biases. And the research has shown pretty clearly that it doesn't really matter whether you have jurors who are not trained in the law or whether you have judges, have got a lot of training experience. Mostly, it's fair to say that the same sorts of biases influence both types of decision makers. So, the challenge for us is to understand the complexity of these decisions, the sorts of things that influence people, and how can we overcome some of those things, or at least mitigate some of the influences that we might not like to see there.
And can you take us through some of the primary cognitive biases that, humans have as jury members? Because obviously it's a very specific type of context that we're in as well, where we're being asked to actually make a judgment on particular set of circumstances and from probabilities and so on. So maybe you can talk us through that a little bit.
So there's probably, you can think about it as two sort of general sets of challenges. One is at the individual level, where you've got individuals sort of processing information and thinking about the evidence as it's presented, and also all the non-evidentiary things as well, like what do people look like, that has an effect on them. Then you've got the group decision-making part, where you then get the group dynamics and the sorts of biases that affect groups and collective decision-making. So at the individual level, the thing about jury trials is they sort of fall into that space where people inherently are going to have some challenges, because the cases where there's really clear evidence that somebody's done something illegal, they don't tend to go to trial, right? People tend to, they know there's a lot of strong evidence against them, so they try to reach, some type of plea deal, or they just plead guilty because there's, an amazing amount of evidence against them. The ones where it's really weak, there's actually quite strong filtering through the criminal justice system, so weak cases don't tend to actually make it to trial. For example, the investigation might not sort of result in it being passed to prosecution, or the prosecution might decide not to proceed with the prosecution once they've got the proof of evidence. So there are multiple points where really weak cases will be filtered out. And there are some challenges around that too, because what leads to the perception that a case is weak is, to some extent, not fully, but to some extent, the extent to which the case is seen as stereotypical or not. Because if you've got a victim or complainant who's not behaving in stereotypical ways, and so like a lot of the sorts of cases we look at as examples are sort of involve sexual violence and sexual assault, and there's strong sort of expectations around, or stereotypes around, how complainants should behave and what they should do. Now, these expectations are not based on reality. They're just misperceptions about how people should react. And so when you have cases that don't match these expectations, they seem to be less credible, or people, even if they personally believe the complainant, project ahead and think, well, the next decision maker is not going to, so there's no point in proceeding with the case. So those sorts of cases fall out a bit, at a high rate as well. So what jurors are left with is typically the cases where there's contested evidence or it's ambiguous. And they're the sorts of decisions where, because they're hard to reason through, it's hard just to sort of look at all the evidence and weigh up the pros and cons and arrive at what an economist might call a rational decision. Whereas, I'm not sure there's any truly rational decisions. But, you can't sort of work through the evidence systematically in those cases and arrive at an outcome. There's going to be a level of uncertainty. And so the way a decision maker will get over that threshold to feel sufficiently confident, is to, use their pre-existing knowledge and expectations. And that's where the biases and the stereotypes live, is, it's your, essentially your mental model to understand the world, how you represent how things typically happen, what people are like. All of those sorts of models help you interpret what would otherwise be ambiguous information, which is normal and functional. That's how we get by on a day-to-day basis. It helps us make choices. But the issue is they're just general rules. So they're often mostly correct, and it doesn't matter if we get it wrong. In a criminal justice setting, the consequences are obviously a bit more severe for getting it wrong. So what can happen is when we apply sort of our understanding of the world or our stereotypes and schemas to make sense of the ambiguous information, we can, incorrectly weight the credibility of certain evidence. The other part we have difficulty with sometimes is making sense of probability. So there's lots of evidence. When some cases, like forensic evidence, will be presented in terms of probabilities, and we know from research that people have challenges when reasoning with probabilities. It's not something we're very familiar with, and it's not something we're necessarily very accurate at, and we fall back to heuristics. And so we'll either vastly underestimate or overestimate what a probability means when we're asked to interpret it. And so this could be, when we're presented with DNA evidence and the likelihood of a random match, like 1 in 10 million or whatever, and we're trying to interpret, does that mean we should feel confident that this sample matches the defendant? And so there's all these issues with reasoning with statistics where people struggle, and so they'll kind of fall back on simple decision rules to help them make sense of that type of evidence.
And I'm assuming that these are some of the areas that jurors will actually be targeted on, in that a good barrister will often try and skew statistics, for example, or probabilities in a certain way, using certain languages to, in many ways maybe exploit such, or maybe it's not even the right word, but use these heuristics of humans when we are overloaded or we find it difficult to understand how to categorize ambiguous evidence, that jurors would often be actually placed in these situations or purposefully confused, even potentially, to try and create more ambiguity and go back to these kind of general rules, heuristic schemas that we use.
So, this is an interesting thing about the criminal justice system in Australia, and particularly jury trials, and it's the same in England and America. We have an adversarial system. And the idea is, each side puts forward their best arguments, and we try and sort of discover the truth about what happened that way. Some other jurisdictions have an inquisitorial system where it's more about sort of the court sort of guiding the questioning, and the goal is to, work towards, discovering the truth in a different way. It's not about combat of evidence and ideas. It's much more about working towards uncovering what's happened. So if you're a juror, this creates a difficult environment, because you've got two sides and they're each trying to advance quite opposing, contradictory accounts of what happened. So they're not working necessarily together to help a juror understand ambiguous information. They've actually got different agendas. So the prosecution's trying to create the most persuasive case possible, within the bounds of the laws around evidence. They'll call experts and, present, and have witnesses and present sort of exhibits, all this sort of stuff. Defense has a different objective. They might have evidence that directly contradicts, what the prosecution is presenting, but they don't have to convince the jury that the defendant is innocent, because that's actually not the point of a trial. You don't have to prove your innocence. The prosecution has to prove the defendant is guilty to whatever the standard is for the trial. So for a criminal trial, it's beyond reasonable doubt. And for a civil trial, we have a very small number of jury civil trials in Australia. It's actually the vast minority of trials. You just have to prove to balance the probabilities, all right, which is sort of 50-50. So the prosecution's trying to get over that threshold. All the defense has to do is confuse the matter, and sort of throw some red herrings in, make you sort of question the expert evidence. And so they can kind of present, really just conflicting information without necessarily having to convince you the person is innocent. They just have to make you less sure that the defendant is guilty. And so they're actually creating that sort of perfect situation for people to have to rely on some type of pre-existing stereotypes or pre-existing knowledge to make sense of what's going on.
And what are some of the pre-existing stereotypes that we hold, and the differences between how genders might do that too?
So it depends on the sorts of offences you might be talking about. But for example, if we're talking about sexual assault, the stereotype about that type of offence is that the typical assault happens, the perpetrator is a stranger, and that assault will sort of happen using some sort of violence, typically sort of, outside. Often it's sort of the evening, while the complainant victim is sort of walking back to their car or something like that. That's the sort of thing you might see represented, in media a lot. And that's when if you ask research participants, just tell me what you think the typical assault is like, they'll describe something like that. So stranger attacks, uses violence, it's normally a blitz attack. And then the issue becomes who was the perpetrator? Like what evidence is there that this person was the perpetrator? Unfortunately, the most common assault is actually an assault by somebody known to the complainant. And so this is, often in sort of some kind of social setting. It's an acquaintance. People could have been, at a party together, socializing, drinking, dancing, or even have been on a date or in a relationship. And so, sexual assault happens in relationships too. And so that looks very different from people's stereotype. So it's numerically much more likely that it'll be an acquaintance assault than it would be a stranger assault. So the most cases that jurors get faced with are the acquaintance assaults. And so it's mismatched with their expectations about, how assault tends to happen. Then there's tied up with that expectations about what a victim survivor should behave like, that they should go to the police immediately, that they should, clearly tell the assailant no and fight back, and that they should cooperate with police and be emotional because it's a really traumatic experience. Now, the research on this is pretty clear that they're actually not necessarily that common responses. Often people actually have flat affect, flat emotion in response to these sorts of traumas because it's a way of managing what's happened, and by the time it gets to trial too, complainants have had time to sort of prepare themselves and be, their objective is much more about making sure they get their story across, so they might appear to be, quite controlled, which kind of is at odds with what the lay perceiver will think somebody who's been through a traumatic experience should be like, and so all of these sort of violations of expectations can lead people to think, well, maybe this person isn't actually telling me the truth. Maybe they're making it up, or, they've changed their mind about what happened. And this is the problem because the issue in the most common case is not about who the perpetrator is. Often that's not the question. The question is whether there was consent or not. And that's not anything that forensic evidence, can easily provide. It's about a state of mind, in two different people, and so then it becomes a story of he said, she said, and you often have quite conflicting versions of events. And so people look at the behavior of the people in the context that they're being asked to evaluate, and they're using their stereotypes to understand that behavior. And so that's kind of how, and those stereotypes are very gendered, because it's all about, we think the sorts of beliefs that are really influential are not just misperceptions about sexual assault and victims, but also misperceptions about consent. People have a lot of experience with consensual sex, less experience with sexual assault. And so they've got quite well-formed schemas or stereotypes. about how, consensual sex, plays out. What are the sorts of behaviors people do? There's a stereotype that agreeing to go upstairs for coffee is a signal that you're consenting, when it's just you agreeing to go upstairs for coffee, and so there's all these sort of unwritten rules to consent that people think indicate consent. And they'll apply that to try and understand what the state of mind of the complainant is and what the state of mind of the defendant is. And those rules come from our gendered stereotypes about people's roles in sexual relationships. And so it is, it's quite challenging in those cases to have people think, beyond those stereotypic expectations about behaviour.
Sounds like it's very complicated, because the schema that we are thinking is likely to be the case in a sexual assault, using this as the example, is almost always different. It's not an unknown person. It's not an attack. There's a lot of ambiguity already in it that kind of shifts our stereotype of how it should be, and poses questions. And that's where that sort of questioning around, does the going upstairs for a coffee mean something? And is there gendered differences about how, from your research and your colleagues, how men and women view this differently? Is there on an average sort of basis, are jurors selected on these bases differently because there are biases between the two?
So jury selection is an interesting problem. I'll come back to that in a sec. So are there sort of gendered differences in how men and women perceive sexual assault? The research is pretty consistent that there is sort of a big main effect of gender. Overall, men and women tend to sort of evaluate victims or, survivor victims who have behaved stereotypically more positively than those who have behaved counter-stereotypically. Like, you still get the effect of the stereotypes, but they have different thresholds. So men generally have more negative evaluations of victim survivors than women. And part of that effect, we think, is to do with that the most common gender for victim survivors is a woman, and the most common gender for a perpetrator is a man. And so there's an element of identification with the two different roles of perpetrator and victim survivor. So if you're a man, you're more likely to identify with the perpetrator, and if you're a woman, you're more likely to identify with the victim survivor. And so your perceptions are going to be more aligned with those two different roles. So women will be more positive about and believe victim stories more, whereas men will be a little bit more sympathetic to perpetrators. And part of that is you're sharing that gender identity, you're in the same group, and that we generally have a preference for more positive evaluations of in-group members. And part of it also is that, well, I guess it comes out of those sort of just world beliefs, there, but for the grace of, whatever deity you want, there go I, so if you're a man, you think, well, that could have been me. And if you're a woman, you think that could have been me as the victim. And so, there's a gendered tendency to view it differently there. Men have a higher threshold for deciding that something's sexual assault compared to women. So there's that. Now, the issue with juror selection, so there's limited avenues for lawyers to influence the composition of the jury in Australia. Like, we don't have a process where people can, like in America, you can give questionnaires to potential jurors. You can go and survey members of the community, where they're going to select jurors from. You can, in some cases, people will hire consultants who will look up people's social media presence as they're being called. So you can potentially object, based on, are they a member of the NRA or whatever, and so in Australia, all you get is a panel of people who are called in. A selection of those get called randomly to go into a courtroom for a particular trial, and then there's sort of a lottery process where a number is selected, and that person's number, they walk from sort of the marshalling area at the back of the courtroom up to the jury box, and you can object before they put their hand on either the Bible or the alternate. You can swear on an alternate source. You don't have to swear on the Bible, but until you put your hand on there, you can be objected to. And really, the only information people have about potential jurors is what they look like. So you can kind of work out their age. You can have a guess at their gender too. And then you've also got what's on the electoral roll. And that's the only information lawyers have. So they'll know what your sort of description of your profession is and what suburb you're from. And so really, gender is one of the few things you might be able to have a go at selecting on. The risk, and having been on the jury and, listened to people's sort of accounts of the selection process, the risk is, though, if you look like you're trying to stack the jury is not sort of ignorant of that. And so they might feel like you're trying to influence how they're going to decide the case. And so the risk of sort of one side, only trying to, objecting to all the women, for example, as defense might want to, it could sort of create the suspicion that that side, the defense, is trying to stack the jury. And there are some benevolent beliefs around gender that men and women subscribe to, but that men believe more strongly. And that's that protective belief around women. So these are sort of the traditional stereotypes around gender roles, that men have to be protective of women. They're pretty outdated, just to be clear. I'm not advocating for these beliefs, but that men have this protective role, and that women need to be looked after because they're more gentle and delicate. So if you are sort of selecting just men onto the jury and you raise suspicion that maybe you're trying to influence what they're doing, and you've, perhaps selected men of a particular generation who are most likely going to believe these beliefs, it could actually backfire, and where they'll become, protective of the complainant, the victim survivor, and actually, not be very sympathetic to the defense's side of the story. So, I think, if you're a lawyer and you're listening to this, what should you do around jury selection? I'd just be really cautious, because the research shows that overall, because you have the group deliberation, individual juror characteristics like gender tend to come out in the wash. Probably in the sexual assault matters, gender composition of the jury is one of the few times where individual characteristics might influence the outcome, but the group deliberation phase, where people have to sort of share and justify their perspectives, is a mechanism for getting rid of some of the effect of these biases.
And so obviously gender, profession, suburb is what we allow for here in Australia. And that could be, for lack of a better word, selected on or manipulated on, but really there's not that much to work on, because we don't really know how this plays out, in the Australian context. There might be some individual differences, but as you say, if you stack it too much, that could potentially change how the group dynamic works rather than on the individual. And there's no research to kind of say, if it's a 12-person jury, you stack it, 7-5.
That's right.
We just don't know, is the tipping point 7-5? Is it 8-4? At what point does it become a problem? And so it still creates at least what we see as fairness or it's representative, because we don't give enough detail. We don't do polling and the rest of it, like what it sounds like the wild west in the US.
And law reform commissions have looked at jury selection, and there's some argument that actually we should limit the number of challenges that lawyers can make. So you get a limited set already, but that we should really only have those ones where you can challenge for cause, where there's an obvious potentially biasing thing, like one of the jurors is the neighbor of the defendant or something like that, or a distant relative. Like, of course, those jurors should not be impaneled. But at the moment, in every jurisdiction, you can challenge because you don't like the look of them. You don't have to give them a reason, and so there's some argument you should actually get rid of those altogether, because in most cases, it makes very little difference what the composition is. And sometimes it's counterintuitive, if you're trying to sort of make the jury more conviction prone, you might think you want to, put older jurors on, but in fact, you should put younger jurors on, and so there's all sorts of counterintuitive effects of things like age and gender. And the challenge is that's all based on research around what typically happens. And if you're trying to apply those sort of large group averages to any individual jury you're selecting, there's not a one-to-one correlation between how any single person will decide a case versus what research shows on average is the tendency. And so, it's a risky strategy. You're much better off just having a really convincing case with evidence. Yeah. That's, and we know that's actually the biggest predictor of jurors' decisions is the strength of the evidence. And so, if you're investing effort in a case, you're much better off investing it in, if you're the prosecution, mounting, a very strong case. And if you're the defense, countering the evidence that's going to be raised by the prosecution.
It sounds very, it's heartening to know as well, because it says that we've got a good legal system, but it also tells us that if you've got a very limited demographic information about the jurors, it tells us that the biases in the group deliberation will come down to things like personality and so on, which you can't necessarily select for because you don't know. You're going based on maybe quickly age, because you can see them, gender, that you can generally see that for most. You might have profession from the electoral roll, suburb, that gives you something, but really there's such large categories that you're not able to sway it too much. Can you talk us a little bit about the group deliberation part in terms of the, how that might play in and biases that show up and that of from the literature there?
So there's I think there's sort of a bit of an expectation that groups will make better decisions than individuals. That's sort of, I think, people's sort of anecdotal expectations and experiences. To some extent, that can be true, but there are biases around group decision making. So, for example, people might be familiar with the concept of groupthink. Now, the evidence for groupthink, which is a form of decision making that happens in high pressure groups where they tend to sort of make bad decisions because they feel under threat and under pressure to arrive at a decision, and they don't sort of adequately consider alternatives and look at the evidence. And so it's and nobody contradicts anyone. They kind of coalesce around a leader because of the sense of threat. And this was proposed in the 70s, and it's been used to explain a whole bunch of poor decision making, like the Bay of Pigs fiasco, the shuttle disasters, and a whole range of other sort of high-level decisions that led to bad outcomes. So the evidence for groupthink is pretty mixed, when you look at the research, and there's a few different explanations for it. But there's a more general problem with groups, which groupthink kind of is an exemplar of, which is sort of the focus on common shared positions. And so, group decision-making can encourage people to really essentially share the information that they think other people have, because it's a way of building common ground, and showing you a good group member, that, look, we think alike, we evaluate this in the same way. And so you can end up with a problem called the hidden profile problem. And that's where, group members might share, say, 3 bits of information. If you've got 6 group members, 3 bits of information are the same, and that's what they spend their time talking about. But each group member might also have another 3 bits of information that's unique to them. And that if they shared that, they'd arrive at a different decision. But because they only focus on the bit that they all know about, they just reinforce each other's shared information, right? So that you kind of get a biased sampling of the information from everyone in a group. There are some strategies you can use to help sort of circumvent these tendencies to seek consensus too early. So one of the things you can do is sort of make people aware that there might be other information that not everyone knows. And so you encourage people to share things that they think people wouldn't know. You just explicitly make that part of the decision-making process. The devil's advocate procedure is another way that people have used in business decision-making settings to try and improve group decisions, where you have one person whose role it is to challenge the group decision. So you make it normative for somebody to take an opposing view, but they have to try and do it relatively genuinely and use the evidence. So they just can't be dismissed as being oppositional, And so the challenge with these sorts of techniques is, for ongoing groups, like in businesses, they can undermine group function, right? Because it makes the group less harmonious, which is why people seek consensus information, because it feels good, right? And it's harmonious and we're collectively in this together, right? But, if you've got somebody who's being devil's advocate, that can sort of put a fly in the ointment in the group and create a bit of conflict, like informational conflict. But, some of the research we've done shows it leads to objectively better decisions when you have that informational devil's advocate role. So they're not being rude to each other or anything like that. They're just putting opposing viewpoints. So the challenge then for businesses is to not undermine group function, so to make it normative, to see it as a valuable part of the group. For a jury, they're less worried about the ongoing group function because the jury comes together for a single case. And most cases are sort of about 5 days. And so, the point is you're not trying to build a cohesive team that's going to work together over multiple years. You're trying to do a single decision. And so, introducing some, opposing viewpoints, all of that can have these benefits of improving the decision making. And then the undermining, the cohesion of the group is actually, or the jury is probably less consequential in that setting. And so I think, encouraging that sort of strategy, and that's something, for example, the foreperson of the jury can encourage. They can make it normative. So there's, the foreperson, there's a perception that the foreperson runs the jury and kind of has an oversized influence on the outcome. That's not borne out by the research. They certainly talk more, but they don't have an oversized influence on the outcome. But
Can you
what
tell us more about what that is, the foreperson? I was about to ask, how does a jury work when they go, and deliberate? Well, what's that process actually look like?
So what happens? When you say when they deliberate, this is the interesting question. When do they deliberate? Because there's a deliberation phase of the trial, which is once all the evidence is presented. But the anecdotal evidence is pretty consistent that jurors start deliberating from the first time they get together in the room. So they'll often be sent to the room for breaks. Like you have to have comfort breaks during a trial, where people need to use the bathroom or get a drink or whatever. You have lunch breaks and all of that. And, the jury will be instructed to not sort of discuss the case or arrive at a decision yet until they've heard all the evidence. But jurors being people,
human nature, sure.
They've just heard some amazing stuff on the stand from a witness. They want to talk to somebody about it, sure. And so they talk to each other. And so they're already sort of working through the evidence. One of the first things they're asked to do, when they are first sent back to the jury room, is to nominate a foreperson. And typically that's the person who sits at the head of the table, and often it's a man, so the research says men are overrepresented as four people. And their role is to really be the spokesperson of the jury. And so they will sort of convey questions to the judge. They will deliver the verdict at the end. And they kind of basically represent the jury. But they have to represent the jury. They can't speak, against what the jury says. They're also... in many jurisdictions, there's sort of some information for jurors about how to conduct things, and the foreperson is encouraged to sort of manage, provide some management of the deliberations to make sure everybody gets to contribute. And that's really where they can come out and make sure opposing viewpoints get considered. That would be a foreperson who's really functioning well. So not going straight to asking for a verdict. Right. So some juries operate by just polling to try and see how many people agree on a verdict already. So we might be in a jury together. We've just finished the evidence. Or maybe we've been talking about it the whole time. We've just heard the rest of the evidence. And so we walk in and say, all right, let's have a vote. Who thinks he's guilty? Who thinks he's innocent? And we might do that anonymously, or we might do it with a show of hands. And then we work out that, Nesh is the only one who thinks he's innocent. Everyone else thinks he's guilty, but we've got to be unanimous. So let's convince Nesh, so the job becomes getting to the number of guilty verdicts we need, rather than evaluating the evidence to see how the evidence matches the different verdict options. So that latter style is more evidence-driven deliberation. So you don't start with a verdict. You start with everyone working together to consider all the evidence and then figure out how it fits in with the verdict options you've been given by the judge. So that's the better form of deliberations, and you're not rushing to seek consensus. You're looking to evaluate everything. And to do that properly, what you'd want to do as a foreperson is make sure everybody gets to have a say and challenge, in a constructive way some of the shared perspectives. Like, imagine if it was not that, if that wasn't the explanation for things happening in that way, or what if that person was actually not the person who we thought it was? And so you work through sort of some opposing viewpoints. So you don't obviously want to consider like ridiculous perspectives, like
Absolutely.
imagine it was space aliens that came and robbed the bank. Like, that's just a highly improbable thing. It's not something you would consider, to get to the reasonable level of to get beyond reasonable doubt. But you do want to sort of consider reasonable alternative explanations to work through the evidence, and then you might end up discarding them and then going with the perspective that certain people have put forward. So it's all just about sort of systematically working through the evidence together. Different people will remember different bits of the evidence, and that's why those sort of larger juries of 12, like we have in Australia for criminal cases, are better, because you've got more people to remember more of the evidence. In the US, it varies, but some jurisdictions have 6 people for criminal trials.
It's quite interesting to hear that, because I can see the influence that a 4-person can have, and it's quite interesting because they don't necessarily have any training in doing that. They're just elected by the group, and all of a sudden it's quite an important way in how these conversations take place. But they're doing it for the first time. No one's there to say, at least as a starting point, here are the 10 principles we're going to do, and then 4-person can kind of continue on. So it might be, everyone gets to go out and summarize, how they've heard the evidence, and give, 3 points that are, shared, and 3 points that are maybe unique, or whatever it might be, to get, from my viewpoint, psychological flexibility, variance in perspectives that allows us to then be much more objective, rather than follow our heuristics and stereotypes. So, someone who comes in and says, well, just out of curiosity, where are we all standing roughly at the moment, and getting a whole lot of, guilty or not. It's like, that might appear to be efficient in that, who do we need to get over the line and convince? And then we've got all of a sudden, a bit of social pressure to go along with it, that we all know about with conformity studies and the like.
Absolutely.
Versus going out and trying to do the job of what a jury is, to be much more objective.
And if
that's a huge position to take, the 4-person. Yeah.
If you're like a minority of one, like if you're the holdout juror, from all those conformity studies that's a hugely risky position. That the pressure to conform goes up dramatically if you're the sole dissident. And so, and it's kind of made worse, is kind of maybe the wrong word, but it's not helped. So for some offences, after a certain period of time, if there's still only one juror holding out, you can take a majority of 11-1. And so, like, the pressure's on that, you've got to either get on board, or we can just ignore you, and so it's just about the verdict, right? So that's why you don't want to necessarily go straight to a verdict vote when you come in as a jury. And the other problem, apart from the conformity issue, is confirmation bias. Like, I think if you commit publicly to a verdict, it makes it harder to change, because you might hear other perspectives, and you're now viewing them through the lens of like, oh, I'm going to take on board the bits that support what I already said.
Yeah.
So I think,
absolutely.
it's kind of risky doing the verdict-driven style. And so if anyone's ever a 4-person, you should really kind of resist that, and just try and, canvass the room for all the opinions first.
And in Australia, is there a requirement that all 12 are in agreement? You said that in certain cases it might be 11, but is that how it usually works, that you need all 12 people?
It's normally unanimous. Was unanimous for pretty much all offences until relatively recently. Where for some offences, it's majority. So either 11-1 or 12-10. Depends on the jurisdiction and the nature of the offence. Or after a certain period of time, if the jury can't reach a unanimous verdict, they can accept 11-1 after being given a direction to reconsider. So these sorts of changes were brought about to try and deal with the issue of the rogue juror, the one holdout who's just not being reasonable, which, depending on how you interpret what getting to beyond reasonable doubt means, does that mean each individual has to be beyond reasonable doubt, in which case, everyone should be in agreement, you should have a unanimous verdict, or does it mean the jury overall just has to generally agree, and so is 11-1 appropriate? What the research shows is there's actually very few cases where there's the holdout is only one person or two people. It's the vast minority of hung juries is a single person holding out. Often it's more of a split, like 7-5, where there's a genuine disagreement in the jury, and individuals can have genuinely held positions that disagree with the rest of the jury. Sometimes not necessarily the case. So we've had a few high-profile cases with single jurors holding out, like in Queensland. We had the trial of the former Premier, Joh Bjelke-Petersen here a few decades ago now. But it turned out one of the jurors was actually a member of his political party, and so that person kind of held out for, political reasons. I think those instances are pretty rare. And generally the unanimous verdict, I think, and the research is consistent with this, does produce better outcomes, because what it does is forces jurors to have to listen to each other. Because if with a majority verdict, if you've only got one person holding out, you've got over the threshold, that's fine. I don't have to listen to your arguments anymore. Yeah. Whereas with unanimous, and this is the whole point about considering alternative viewpoints, with a unanimous verdict, we really have to make sure everyone's had a go sharing their opinion.
Function. Yeah.
It is, absolutely.
That, yeah.
And I think that's actually a really good thing, because they're really important decisions, and they're very consequential both ways. Like, a defendant could go to jail in the criminal trial, which is when juries are normally called. They could go to jail, lose their job, a whole range of different, outcomes taken away from their family. And for, victim survivors in sexual assault matters, or people who are victims of crime more generally, if somebody, if a perpetrator is acquitted, but they actually did do it, so the jury makes a mistake, or if you want to characterize it as a mistake, or they just couldn't get over the threshold of confidence, is probably a better way of thinking about it. That's consequential for victims as well, like their sense of safety, their feeling that justice was done, the community's confidence in the criminal justice system. So either way, mistakes both ways have a big effect on people's lives. And so it is really important to get it right, and make sure that whoever the decision maker is, so a lot of decisions are made just by judges as well, like at magistrates level or county court level, that those decisions are, are as accurate or based on the evidence as much as they can be.
Like, I am mindful of time, and I do want to still ask that question around the different modes of presenting evidence and how that plays in. Are you able to at least speak a little bit briefly on that?
Absolutely.
Because I know we need to wrap up soon.
I've got a little bit more time. I think we might be having a daylight saving time.
Okay.
Yep.
Okay. So, wonderful then. Oh, yep. No, my apologies then. I was starting to get nervous going, oh my goodness, there's so much more to talk about.
No, I think that's daylight saving.
Talking Canberra time. Good. Okay.
It's all good. So modes of evidence. So there's two issues in talking about modes of evidence. One is to do with how evidence is presented in court. So that's one thing I'll say a couple of words about too. And then the other one is how we do research on juries, which is really about the mode of study or simulation, if you like. So for the first issue, there's a lot of accommodations that are being introduced, which are really positive to support victim survivors tell their stories. So like video recorded evidence. There's protections for child witnesses. They can give remote testimony, from a room linked via video, and all these things are really positive, in terms of supporting people who've been through traumatic experiences, through the offender's actions, because turning up in the courtroom can be really stressful. It's not it's an unfamiliar environment. particularly for, if you're a child going there, it's very confronting, and the perpetrator may be in the courtroom there. And so, all of that is things that are going to interfere with your ability to tell your story, and that are going to be quite traumatic to experience again. So, one of the challenges, though, is that giving your evidence via these sort of different modes, it can have consequences for how people perceive it. And so I've done a little bit of work with, the size of the video display that's played in court, whether it's pre-record or a live link, because, one of the things we know about stereotypes, is they're often, they come to mind when cues to those stereotypes are particularly salient. And visual prominence, so the size of, someone on a screen, can increase the salience of cues to the stereotype. We start thinking about them more as a child, and then our inaccurate stereotypes about children's unreliability, in terms of their memory, and their ability to be influenced by adults in their lives. So they're actually relatively inaccurate stereotypes about children's memory. But, we've got some evidence that shows that larger sort of displays make those stereotypes more available in people's minds, because it's more obvious to you that they're a child. And this is consistent with some of the work that's come out of the persuasion literature, where you look at how messages might persuade people. And, with most persuasive messages, you've got the content of the message, and then you've got all of the stuff around the message that's not to do with the content that might affect its persuasion. So, is the person giving us the message attractive, or are they an expert? Do they look like they know what they're talking about? All of those sorts of non-content-based bits of messages. And, we know that, more complex messages, it will go, things that might be affected by stereotypes are better presented in text, because it's easier to comprehend complex messages in text, and those sort of peripheral cues are less salient, right? Face-to-face communication makes the peripheral cues more salient, and makes complex messages harder to convey. And that's why you see on TV advertising, if somebody's trying to sell you face cream or something like that, they're going to have somebody who looks like an expert. They're in a lab coat, and they've got a really simple message about how using this face cream does sciencey things to your skin and makes your skin look younger, but they're very vague about what it's doing, because they're hoping you'll just look at them. They're in a lab. They've got a white coat on. They know what they're talking about, right? I don't understand the message, but that's fine. I'm going to go out and buy that face cream because it's got some science stuff in it, and that's going to make me look younger. The expert told me, and so face-to-face communication can tend to emphasize those sort of stereotypic cues, and the more prominent those cues are, the more easily they come to mind. And so that's why, when you're thinking about how evidence is presented, sometimes people do telephone links for evidence as well. If you're, if you've ever been I don't know if there's anyone listening who's been an expert in a trial, sometimes experts who can't get to the courtroom will just phone up and do it via telephone. So that takes away a lot of the visual cues to what the person looks like, which we might use to judge their credibility. And so that sort of mode of presentation can either ramp up or ramp down the effect of those cues. And so it's just worth thinking about when we're designing courtrooms. We've done a little bit of work on architecture of courtrooms, how much prominence we're giving to the cues. And I think probably the right mix, is life size would be reasonable, because that's what you'd get if somebody turned up in court. So not sort of like on a huge screen, but kind of, positioning sort of video displays roughly so it looks like people are sitting at tables in the courtroom. And we've done some simulations of this with the industry partner, where we actually took over a courtroom and, put in video links everywhere and had people sitting in different parts of the courtroom on video link, or some in person, and we were able to test. This was the work on when you're, how is a defendant represented in a courtroom? Does their representation in a courtroom bias how we perceive them? So in Australia, they're often sitting in a dock, which is a separate area in the courtroom, away from the jury and away from the legal counsel, and in a lot of courtrooms, that dock might have glass around it for public safety or for the defendant's safety. And in some courtrooms in New South Wales, those docks are actually built into the wall. And so there's an option to put the defendant behind glass in one wall of the the courtroom. So they're quite separate. And, what we've found when we manipulated
it personalizes, doesn't it? It kind of says that, it's
they're
us
dangerous.
versus him,
Yep.
or her.
Yeah, absolutely. You're creating another thing. Yeah, they're not even a person to some extent. Depersonalizes them, but it also, we've shown it sends a signal. Maybe they're a bit dangerous as well. We have to put them behind these structures to protect the public. So you there is a presumption of innocence, and here we are as giving an architectural signal that maybe this person actually has done it. And what we found when we sort of systematically, with lots of different trial jurors and juries run through the simulation in an actual courtroom and moving the defendant between different places during a terrorism trial, is that the defendant's seen more negatively when they're either sitting on their own in a glass dock or sitting on their own in an open dock. The only time when you don't get that negative perception is when actually sitting at the table with the lawyer. So when they're part of proceedings, right, and treated as an equal there. And that's actually ironically where defendants often sit in American courtrooms, is actually at the table with the lawyer. But what you don't see is they're chained to the floor under the table, right, which is kind of problematic for other reasons. But so when you've got this sort of co-location, you don't have those negative perceptions of the defendant based on the fact that they're separate from us. And that works on video as well. So defendants will sometimes appear via video link from wherever they're being kept in custody, and the lawyer will be in the courtroom. And that's a little bit problematic because it's the same as putting them in a glass dock. In a similar way, you're sending that signal, about
they're dangerous.
They're dangerous, right?
Yeah, separate.
And it's super efficient though, because you don't have to drive them into the courtroom and do all the security around that. So what we've found though is if you have the lawyer and the defendant on camera together on the same screen, you get rid of the negative effect. And so there's things you can do to kind of still gain the benefits of why we do it that way. But without necessarily prejudicing the trial, presumption of innocence for defendants.
It's interesting because as you're talking, for me, I'm hearing something similar to the way that we try and do psychometric testing. We're trying to do standardization. Like, if we do standardization of screens, a large screen, every business wants a large billboard versus a small billboard, because we know that one's much more effective. And, maybe it's because it takes up more of your visual field. Maybe it goes out and activates more of your occipital lobes, triggers more emotive response. If someone is crying and you're more connected because you can see more of it. There's so many things. Obviously, I'm not talking from a scientific nature, but, assuming, putting hypotheses out there. But I could see how the standardization approach that is coming up, at least from what you're talking about, is if the prosecution is all together to go and have the defendant separate, doesn't standardize it, and immediately sends a signal that we will cue to. We make assumptions of even some sort of physical wall, and hence this whole concept of does someone come in, and do we support the surviving victim by putting them in a video link? We want to go out and assist and help in that way, but could it be potentially detrimental? Well, it depends on the size of the screen, depends if they have someone next to them, and so on and so forth. And this is so fascinating that how much of the system needs to be reviewed from a psychological perspective to make sure that equity, fairness is at least minimized as much as possible.
Yeah, you don't want to do things that are going to undermine the presumption of innocence, but also things that will traumatize people who are witnesses or survivors, because that's not fair either. And it doesn't do anything for for people participating in the criminal justice system if they feel like it's going to be a traumatic experience. So I think the message shouldn't be, we've got to get witnesses to always come in and give their version in court. We need to sort of think through, how can we support people with these, these really, they're very positive interventions, allowing this sort of video evidence so people don't have to retell their story over and over. So there's a recent case that's just started up again, I think, in Queensland, and they're going to just replay the videos of the survivor's testimony. And so I think that they're really positive steps. But then what do we need to do? Do we need to educate jurors about what inferences to not draw from video evidence being used? Do we need to make sure the video display is an appropriate size, so that, like you said, the larger displays, we look at them more, right? They're very attention getting. And we know, that we tend to attribute causation to the things that have the most sort of attention grabbing features in an environment. So if it's not the same as a courtroom, but if you look at confession evidence that's video recorded, or interviews that are video recorded, there are certain camera angles that if you use them where you only show the person being interviewed versus both the interviewer and the interviewee, in like a police interview, it leads to more negative perceptions, and people don't believe the defendant, to the same extent, because you've got too much perceptual focus just on the person being interviewed. You're not taking into account the behavior of the person interviewing them. And so it is important to get those things right so that they're fair, but that we still get the benefits of using those sorts of technologies. And there's a lot of gains that can be made in that, and I think also in making sure we're telling juries the right things about, not to infer that a survivor not turning up to present in court doesn't mean that they're not genuine, which is an old sort of stereotype that if somebody didn't bother to turn up into court and we have to use a video of their evidence, that for some, that doesn't mean that they're not genuine, right? That this is actually the mode of evidence delivery that is normal and expected in these cases. So a bit of the picture is making sure we kind of set expectations with what we say to jurors so they can understand why they're seeing evidence delivered in these different ways. So I think that's the other part of the story that's the onus on the system, and also academics to help sort of develop and evaluate those sorts of instructions to make sure they do have the desired effect. But helping people navigate, jurors navigate what is an unusual context for them, so they know why certain things are happening and they're not jumping to conclusions based on their own sorts of beliefs about what might be happening.
Three things have just come up as you were speaking. The first one is even the moderator of volume. I watched Top Gun 2, being a young gentleman when Top Gun 1 came out, and the first time I watched it, the sound was phenomenal. And I went back for a second time as other friends wanted to go along, and it was so disappointing. The music, the sound quality was much lower. It didn't have the impact. And so even how sound is, depending on video link versus in person, could be vastly different. That's one thing that came to mind. Second one is that size again. I've been watching some videos on the Twitter files, and quite comedically, I was sort of laughing about any time that one of the presenters was trying to make a point, they would bring out almost like those large checkbook cards where people, when you used to write check, they would bring out this big, large one, like when someone wins the lotto, and it would have, an email on it, but it was so large. And I was just thinking, this is that size effect that it makes something seem like it's bigger rather than just reading it out. They would bring it out, not that anyone would probably even read it out from this ridiculous looking sort of, lotto winning card, but the props were phenomenal in how they were doing this. And I was kind of laughing at just wondering why, but this is making much more sense now having discussed this with you. And the final thing is looking at this structural thing around potentially mitigating biases as a systemic sort of play that the courts could do to help with maybe psychoed or educating, so that we can, as jurors, be understanding of how we're operating or how we're thinking, so that we can kind of at least mitigate some of that. Because it surprises me still that the foreperson has no training, or that we don't help to mitigate these things, because these are such important things that if we're going to put people potentially in in front of a 10-day trial, and then, maybe some little bit longer of deliberations and so on at the end. Maybe we should put them through a day of psychoed or ongoing, if there's professionals that are, court appointed to go out and be biased, to be objective. My apologies, and maybe you have to police the police, but to be objective so they can help the courts, aid the help in objectivity and whatever this possible rationality / objectivity / using evidence to inform a decision. So they're the three things that came up. Are there mitigation things that come up that the courts do to try and offset the items that you've and I'm assuming you've this is part of your research, and then trying to inform the courts as to how policies and future courts do things?
So, yeah, there's certainly guidance for jurors about how to conduct deliberations. Like, the courts have invested quite a bit of effort in putting together handbooks for jurors. But, it's that thing, how do you train somebody to be an effective facilitator? It's probably a bit more than a handbook, right? Like, people, what courts try to do is trade off how long they've got people for. Jury service, it's an important thing that people are asked to do. They're not paid very well to do it. And so there's sort of a balancing act of trying to, engage people to do jury service. People are kind of juggling all the demands on their lives. So a lot of people try to get out of jury service. I mean, I would encourage anyone who's called up to actually try and do jury service. It's a really important responsibility I think you have if you're called up. But, the courts don't have people for an endless period of time. It's expensive to run trials. And you don't actually know who's going to be selected onto any single trial. And this is the challenge, where you can have a pool of people called up for potential jury service over a 2-week period. They'll get a message. It used to be your number got put in a paper, and you had to look up each day to see if your number was on for that day, and then you had to go into the courtroom and be available. Now I think you get a message, and so you turn up, and there might be 150 of you just waiting, and then when the different courts are ready, the jury managers or the sheriffs will take a selection of people in. A range of numbers, and then you have a selection process in that courtroom. And you might do that 3 or 4 times in a morning, and then be sent home for the day and not end up on any jury. And then, a week later, you get called in to come in for another day as well. And you might do it, you might go through 2 weeks and never get selected on a jury. Or on the first day, you might end up on a jury and then go through that trial and then end up on the second jury. And that's your 2 weeks jury service. And you might be in the courts for the whole time. So it's really hard to know how you could train people, because you don't know who's going to get selected. So it's kind of, you have to try and capture everyone by giving everybody the handbook. And I think that's kind of like the satisfying solution. That's about the only kind of practical one at that point, unless, you were willing to devote more time once people have been selected to do a bit of training. But I can tell you it's super expensive per day to run a trial. So I think it's something like $50,000 a day or something crazy like that for a typical, trial, not a high profile case or anything like that. And so, if you say, let's devote half a day to training a 4-person, everyone has to wait, because you've got to wait till everyone's selected for half a day. That's pretty expensive. So, it's working out what's the right balance of providing support to jurors in a way that doesn't slow down, and become very expensive, because already the issue is getting through the cases. There's a lot of demands on the courts to meet the needs of how many cases need to be tried. So the other way to do it is, you can use those booklets, but also to provide, for the judge to provide education as part of the instructions to jurors. And that's an area that there's been a bit of work on, and it's about sort of identifying the issues as they arise in a case, and then providing the appropriate instructions to help jurors sort of work through those issues. And that might be, for example, how children's memory works, so that jurors have correct information to understand when children are reliable, and when they're going to give accurate testimony, which turns out to be pretty much all the time. Like, kids are actually pretty good at that. but the stereotype is, that there's big challenges with children's memory, but it's just inaccurate. And so some model, instructions have been tested in research, and, they've been shown to be helpful. Other, New South Wales recently introduced instructions around consent and how to interpret, victim emotion and things like that. Unfortunately, some of the research on that says those sorts of instructions might not always be effective. And so we've got to really make sure that if we are going to give instructions, that they're simple, because a lot of instructions are not written to help jurors. Okay, so there was a big review of instructions down in Victoria a little while ago, because for some, 3-day trials, there would be 2 days of instructions and summary at the end of it. So half the time would be giving jurors instructions. And the reason why that happened is because one of the functions of instructions is to help jurors. The other function is to protect the jury verdict against appeal. And so there's this notion that as long as the correct instructions were given, the jury verdict is sound. And so what practice started to become was, let's make sure we give every instruction that could be relevant so there's no basis for appeal, because really misinstruction is one of the few grounds for appeal in a jury trial, because a jury doesn't write out its reasons. So you can really only go on how the judges conducted the trial. And so the judges would sort of proactively try to defend the verdict because of the expense and time put into a jury trial by giving the jury a whole range of instructions, some of them which didn't even apply to the case, because certain, offences might not have actually been alleged. Like sometimes you would allege a sort of a constellation of offences, like murder and manslaughter, depending on whether intent, you think you can improve intent or not. But, a prosecutor might decide to just go with murder, but the judge might give instructions about manslaughter as well. And so what it does is creates confusion for the jury, because there's all this information that's actually not strictly relevant for the decision they've got to make, but it protects the decision against appeal. So people have kind of moved on a little bit from that, but there's still a tendency for some instructions to use, how could I say it delicately, legal type language rather than plain language that most people would understand. And the research on the complexity of the language and concepts is pretty clear. So you need to be able to make instructions conceptually simple for them to be effective. Otherwise, people are not going to be able to follow the instructions accurately. And then there's the other bit with instructions. It's not just comprehension. Even if people can comprehend them and they're willing to apply them, sometimes people might not be able to. So one of the instructions about biases is sometimes people will be asked to just ignore certain information or to put all their biases aside in arriving at a decision. And those sorts of suppression instructions psychologically are really hard for people to do, because to suppress something, you have to remember what it is. You have to monitor to make sure that you're not relying on it. So if you tell me to, forget about that news article that was negative, I have to remember that there was a news article that was negative to make sure I'm not recalling that there was a news article that was negative. I have to monitor my memory. And so that actually makes it much more accessible, and it can actually have a rebound effect where I'm over-influenced by the thing I was told to ignore. There are strategies you can use in terms of giving people a reason for why you would ignore something, which discounts the validity of the thing. That tends to be more effective. So there is a way to give instructions that map onto people's sort of psychological processes that make them more effective. And we only know how to do those things from research, because it's hard to tell from real trials whether an instruction's been effective.
Can you talk through some of that research, the research that is, highlighted for you as fairly groundbreaking, or has got really good methodology, the research that you've done, how you put that together? I know this is quite broad, but I'm interested in how do we do this? Because this is such an important space, because it is extremely informative of what occurs in a courtroom and how people are treated when they are accused, or when someone is a victim of some crime, and in other scenarios as well. So, what are the some of the research methodologies that you've done yourself, and others that you're impressed by, and how have they shaped and informed the legal system?
So in most jurisdictions, it's really hard to do actual research with jurors because there's the Jury Act sort of prohibits asking jurors about what happened in deliberations, and quite rightly so. Jury deliberation should be protected so that people feel like they can have a robust discussion. But it does make it hard to sort of figure out what happened and unpack the sorts of things that might influence them.
So there's no one's allowed to have post-conversation about what occurred in that room. I mean, there's almost like for lack of a better word, but a gag order of saying to protect everyone and not put, I suppose, the legal system in question. You're free to speak openly and freely here, and that remains in confidence. It's understood that it won't be discussed after the trial ends. Is that what you mean?
So there's a general prohibition on approaching jurors to ask them about what happened. So a juror could come to you and talk to you about what happened, but you couldn't put a call out and say, hey, I want to talk to jurors and ask you about what happened in your trial. Like that would be a breach of a lot of the jury acts around Australia. What you have to do if you want to talk to jurors about their experiences is you have to get the approval of the courts, and essentially I think it ends up going to the Attorney General. So there's sort of a complex process, and we've done that a couple of times where we have actually been given permission to survey jurors, but it's always about a limited range of topics you can ask. So you can't ask about the verdict. You can't ask about was there disagreement, in reaching the verdict, or what they thought about the verdict. But you can ask them about, some people have done research on jurors' experiences, how stressful it was, or, what were the facilities like all of those sorts of things. We've asked them about, what they thought about the expert evidence, how well was it presented. We've asked them about how strong they thought the case was, so all these sorts of ways of trying to understand the things that influence them within the bounds of what we're allowed to ask. Mm-hmm. So, you kind of get a limited window into it. It's really valuable to do that research, but, there are some sort of bumper bars up around the sorts of topics you can ask, quite rightly. And the other problem is with real trials, each trial has got its own particular context, and you can't sort of at the end of it say, all right, well, that was interesting. Now the defendant was male. Let's rewind. Let's run the trial again with a female defendant and see what happens, because we've got a hypothesis about how people think about violent behavior as a function of gender, right? So you can't do that with a real trial. So what happens with studying real jurors is you'll learn a lot about a limited set of topics about this specific case. And that's kind of an important part of the research spectrum. The other bit is when you want to start to figure out what's affecting how people see a case, so what's influencing them, and whether you can come up with an intervention to sort of change the way people see things because you've identified something problematic, like the effect of a stereotype, for example, or some kind of decision cue or heuristic. So the way to do that is you need to use a different research method, and typically that would be done using an experiment. And so that means you sort of need to be able to recreate a case multiple times and run it with different things in it. And so you can't do that with a real case. So case study research and actual jury research can help inform what you might sort of investigate in an experiment. So if we identify jurors sort of are having particular challenges with expert testimony, they're finding the language complex, or, the form of presentation, we might then start to generate some theories about what's going on. And so then we would decide, well, let's test those theories by doing an experiment. And so we would set up a situation where we try and simulate a trial. Now, I said before, a trial might go for 5 days or something like that and cost sort of $50,000 a day or something, super expensive. We haven't got the resources to do that, and we can't get research participants to give us 5 days of their time, right? So we've got a couple of options. We have to make some choices about how important realism matters. and what sort of realism matters, right? Do they need to have a whole case, or do they just need an expert's testimony, just what the expert says? Can we just give them that and ask them about that? Can we give them a summary of what the expert says? Do we need a photo of the expert, or do we need a video of somebody pretending to be the expert? Now, the challenge is the more realistic you make it, you get back to the problems with the real cases, right? So if you have a video of an expert, we now have to be worried about, what do they look like? Are there any cues about what they look like that are going to interfere with our ability to test our predictions? And so sometimes making
too many variables rather than trying to maintain controls.
Yep,
so
that's
that
the trade-off of realism and control. And so the way we tend to think about it, or in my research group, it's not about realism, as in how similar is it to an actual trial. We think about it in terms of psychological realism. How much you're recreating the same experience that you're trying to understand of a real trial. And so that might be replicating the sort of complexity in the decision, or replicating the challenge with the complex language an expert uses. So not worrying about this, you're not showing them a video of an actual trial. So you pick the level of realism that's suitable. So if you're interested in studying, let's say, the effect of a defendant appearing via video link, you can't necessarily do that with a written scenario. You probably need to actually put people in a real courtroom, and we've done that. So the doc research I was telling you about, we actually co-opted a courtroom in Penrith, and that was organised by one of my collaborators, and we ran a trial multiple times, over the course of a couple of days, to get lots of examples of juries going through under different conditions, and so that was a big effort, and but it was worth it because of the question we're looking at. But if we're looking at, for example,
it's very impressive, I must say. Yeah.
Well, I mean, all credit to my collaborators on that one. They did the heavy lifting. But another, if we're looking at expert testimony, we might just have a written, 10-page written excerpt of the testimony and give that to people, and vary, for example, the name of the expert to manipulate gender. So we can get around using a photo and we just manipulate the name. So now we know if we get a difference, it really is to do with the gender. It's not just that one woman who we happen to use in the photo is viewed differently from the one man, right? Like, so to rule out the effect of any particular photo of a man and woman, we'd actually have to probably get like 20 photos of men, 20 photos of women, randomize them all. And so it becomes more complex and we don't gain much. So the first step would be just to use names and see if there's an effect there. And if there is, it says, there's this big gendered effect, because all you have to do is change the name. And this is actually what we find. If you change the name of the expert who gives, complex testimony, people believe it more when it's coming from a man than a woman, right? Because we have gendered expectations around language. We don't expect women to use complex language, which is really old-fashioned, terrible stereotype. Whereas men, it's more acceptable to kind of use jargony, technical language, because we kind of have a stereotype. There's sort of roles that men take, right? And so that's all you have to do is change the name of the expert, and you get greater damage awards. People believe the testimony more if it comes from a man than a woman for complex testimony. And so, you can be pretty confident that that's what's going on, because we've only varied one thing. We've given people exactly the same thing, and we've only varied one thing. But the problem is when you go to practitioners, the courts, and say, look at what we've found, all we did is change the name, and we get this big effect on expert testimony. You've got some issues with gendered stereotypes and expert testimony. The reaction, quite understandably, is that looks nothing like a trial. And that's got no relevance to what we do in court. In court, an expert's standing there in front of them, and there's leading questions, there's questions from the barrister, and, there's jurors get to talk to each other, there's deliberation. That's how they help understand the testimony, and all those things are true.
Sure.
But the issue is what we've done is separated out the language complexity as the single thing we tested in that experiment to try and look at causal relationships. So the only thing we can do then is do other research, looking at, does how you simulate trials matter for what you find? Like, does the method of research have an effect? And a whole bunch of people who are super smart have done this over many years, and they've done it through experiments. They've done it through meta-analyses, and a meta-analysis is where You look at pre-existing
Yes.
research and you kind of like aggregate the findings over like a couple of hundred studies, and then you're able to look at systematic differences in the research and then look for systematic changes as a function of whatever the variable is you're interested in. So in our case, it would be mode of simulation used in the research.
And that's such important research, because that's actually asking the question of, can the courts continue to dismiss or discount our research? You know, we're actually researching our research in many ways as to whether it applies, because you know there's no point if it's not going to be adopted. We have to go out and be robust, like, you know, meta-analyses, to go out and say, yeah, there's something actually in here, even though it, you know, well, both things can be right. You know, it doesn't have all of the features. There are a lot more extraneous variables. Having said that, it still does apply that they are both true. They can both be true at the same time.
That's exactly right. And, you know, I don't think we'd ever get to the point where you could have a fully realistic trial and be able to be confident about what the mechanism is, because you just can't have that level of control. Like, you would learn a lot about a particular trial, but then the trial's over and we have no idea whether what happened in that trial applies to the next trial.
Yes.
Because it's going to be a completely different context. And so we've got to get rid of, you know, all those contextual variations and get to the fundamental principles. And that's what the systematic research lets you do. So the challenge is, like you said, how do you convince people? You know, and those meta-analyses are pretty convincing. They kind of suggest, actually, it doesn't make a lot of difference how you simulate things. You know, there's some issues around, and actually the participants don't matter that much either, whether you use jury-eligible people or students. Like, that's been another big challenge as well, because most research is done on students for convenience. You know, it doesn't make a massive difference to what you find. There's a little bit of evidence that consequentiality, so, you know, what you associate with the outcome, you know, somebody going to jail versus, you know, I'm doing my research study, I get my credit at the end of it. You know, the outcome of participating is very different.
Sure.
We don't know enough about that yet, but, you know, there's lots of anecdotal evidence that real jurors don't seem to be, you know, highly motivated by the consequentiality. You know, there's examples of jurors doing Sudoku while they're listening to the evidence, or watching DVD players, you know, behind the barrier, you know, watching Little Britain on a DVD while they're listening to the evidence. Like, there's all these examples, you know, of jurors falling asleep, where it's hard work, right? You know, it's a long process of sitting there listening to stuff, and people's motivation levels fall off. And so I'm kind of, you know, I think the idea that jurors are going to be way more motivated than research participants is a nice idea, but whether in fact it's true, that's a question that's not really, we don't have a good answer for that yet. So, you know, on the whole, I would be reasonably confident about making some general statements about, you know, translating from research to practice. The trick is, how do you bring along people who might not have a training in psychological research, who understand, you know, why those sorts of decisions are made. And I think that's where you kind of get into a bit of a persuasion effort, where, you know, part of that is doing the work to work with stakeholders, you know, from across the criminal justice system, and make sure you have a blend of research methods where you can do experiments, but also do the much more realistic stuff, and then link it to what's actually happening in real cases to show the whole picture. Say, yes, we find this thing in experiments. I acknowledge your concerns about the realism, although research says maybe they're not so problematic. But even when we look at case file research, we get a very similar finding, even though we can't explain the mechanism. The experiments help us understand the mechanism that might be going on in the actual cases. And so you kind of need to sort of meet people, I think, with where their experience is, and, you know, help sort of make that link between the experimental research and translate that into practice for people.
How open is the legal system to, you know, the research that you're doing? Are they, you know, quite concerned because it, you know, creates change, or it puts into question how things have been done in the past? Are they kind of open-minded and saying, yes, we're quite interested in improving our systems, and open-minded to continuing to improve outcomes, you know, not being biased, just looking at what is supposed to be, you know, held in the highest of regard of objectivity, and, you know, a system that continues to uphold those values? Do you get pushback what biases are you seeing in the space?
Well, I mean, there is an understandable conservatism is the wrong word, but like the legal system sort of works on precedent and the long history of decision making, and I think that's for a very good reason. But also, like the legal system is made up of a very diverse range of people who have got different opinions about things. There's huge disagreement about things like the jury system and that. And I've had a lot of positive interactions with judges, very senior people in the legal system who are very interested in learning about this and changing practice to align with what we know from the evidence. And judges' conferences, often engage with these issues. Law reform commissions have been very much on the front foot in terms of thinking about these things. So, the Victorian Law Reform Commission did the review of jury directions a while ago and looked at a lot of the psychological research on directions and used that to inform their recommendations. They recently did one on, actually not that recently, a couple of years ago now, on jury selection and engaged with all the research on jury selection. The other issues around more general issue of biases. The Australian Law Reform Commission just recently did a whole review of judicial impartiality, which is sort of engaging with the issue of the extent to which judges can be impartial in their decision making and what are the sorts of risks associated with judges' decisions. And they were really open in engaging with researchers and seeking input and sort of working through the issues. Anyone who's interested can get their report off the Australian Law Reform Commission website. And they kind of just sort of canvass research and expert opinion on impartiality and kind of arrive at the position a lot of the things we've been talking about today. There are these sorts of biases that everyone has, and it's really, we just need to be thinking about the sorts of decisions we're asking people to make and making sure we structure them in a way that helps people make good decisions. So there is really good engagement, I think, at some really sort of key points. So I think people are open to hearing about it. Obviously, it's kind of a big ship to turn in the ocean. There's a lot of players, and so it does take a little while for practice to change. But perhaps that's reasonable. That there's not sort of wild swings in practice. I think that's okay. I think that's actually a good thing. So it's really just keeping that conversation going. You're always going to get people asking you, but how can you be sure about that? Or my experience is different. Because people do have a lot of experience. And they feel like, for example, that jurors understand directions, where they feel like jurors do a good job. And part of that is because for people in the courtroom, jurors look like they're doing a good job. Like they look like they're attentive because there's strong social pressure to look like you're following what people are saying. It's rude to fall asleep when somebody's talking to you, but then it's just about having that conversation about, well, what, let's, look at some examples where you think, that might not be the case, or what leads you to that, and then linking that to the research evidence and just having a conversation with people. So I think there's probably very few people who are completely ideologically opposed to research. But, it is, sometimes it's not a comfortable space for people because it's not what they're trained in. And so I think, it can take a bit of conversation to sort of, get on the same page about, what the issues are and what are good ways to address them. There can be a sense, and I think it's probably the same, as an academic, when you have people come and tell you how you should be teaching your course, it's a bit like, well, I've been teaching this for ages. I know how to do it, and I know my students learn. It's a bit like, well, who are you to come and tell me, what to do? And that's hard to argue with, right? So
a threat creates an immediate response to defensiveness, and so a threat of, hey, we just want to look at this is quite concerning. Just to even look at it, which has its own challenges, and obviously natural biases there as well. A couple more questions, because I am now mindful of our proper time. Obviously, you're a professor and associate dean academic at UQ. What would you like to see from all of your experience and research for the future in this area about how do we, work, with the legal system and psychology, combined, and obviously, scientific method too. What areas should we be looking at to focus on, and improve?
Well, I mean, it's kind of just following on from what we're talking about before, but I just think sort of having an open collaboration, just being data driven. Like, I'm not an expert on the legal system. I'm not a lawyer, right? And I'd never finished my law degree. I've never practiced as a lawyer. So, it takes expertise from the legal system, but also from research, to work together to help sort of meet the challenge of how do we support people to make decisions. And so I guess that'd be the one thing you'd sort of hope for. And part of that is through education. We've made an online MOOC about the psychology of criminal justice that people can do on the edX platform. And part of that is also just sort of, getting out there and engaging with people, talking to people about research, going up, speaking at conferences, going to meetings, all of that. And I think that would be the ultimate goal for me. Like, there's particular research questions I think I'm keenly motivated to sort of advance, or, research agendas, in terms of, that making sure that, victim survivors get a fair go, because they're not represented in cases, they're treated as a witness, but that they actually get a fair go and they're not sort of evaluated unfairly based on stereotypes. I'm keen to see that kind of specific outcome, but I think the more general principle that things are just based on research evidence, just like we want trials to be based on the evidence. So we should be making decisions around how we run the criminal justice system based on evidence, which is really the same principle that the law wants as well for its own decisions. So that would be the ultimate goal for me, is that open collaboration and being open to research guiding practice.
I think it's one of the most important parts of, collaborating, is that there's an openness from both, because even science has its extreme limitations. If we go in and we want to demonstrate and prove something, we can fudge the data. We can go out and, try and create it in a particular way to make something sound sexy and interesting and get a publication, and likewise, there should be natural hesitations around that as well, because if the legal system is going to open itself up, it needs to also have a great trust that really good, thorough research looks at it, that's looking to advance, not criticize and be accusatory, but advance and support, whether it's victims, whether it's defendants, whether it's the lawyers in the space, whether it's family members of all of those people who are looked up, the community, the outcome, so on. I think the data-driven space, as it is in psychology, and truth be told, in everything else that I think has advanced immensely, is the key. So I'd have to agree with that as well, and that really, I think, comes down to relationships. That can researchers connect with their fellow colleagues in as professionals, to go out and say, we're really curious and this is really interesting, and we both want the same. Can you open up your system a little bit more and allow us to, with reasonable provisions, like to inform and assist and guide and help. Like when we write, I know that whenever we write a report for the court, you have to go out and write that very particular phrase that you're doing it in an objective manner to inform and support the court, to assist the court, not in any other means. And that, I think, it's a very powerful paragraph, and it should be on every document, because it reminds everyone that if you're the author of this, what are you authoring and for what purpose? And so I think it's a beautiful way, for example, as one small reminder of many, as to what we're trying to do. We're trying to assist the court, rather than potentially advocate and have our own biases and all sorts of things that psychologists get caught up in as well, because we're human.
And I think you mentioned a really important bit in there around our own obligation to be open and open up. And you're right. Like, I think psychology has shone a light on some poor practices and research. And they've been difficult stories to hear, and it's certainly been a bit of a difficult reckoning about some of the research practices in psychology over the last 5 to 10 years, with, people chasing publications with sort of flashy effects and, motivated data analysis that really capitalized on, type 1 error rates and, poor research practices. And so, I think, if you're going to, ask people to collaborate with you, we've also got an obligation to be open about what we're doing. And I think be realistic about the limits of research, but also be, transparent in what we're doing. So sharing data, committing to predictions and research questions and sharing things in an open way that other people can access, for example, on open science platforms, and I think that is a big way to restoring some credibility and trust to research is to, engage in those open research practices and the scientific method. I think it's okay when you do research to be wrong about what your predictions are. That's how you learn more. And so I think we shouldn't be shy away from, committing to what we thought before doing research and then evaluating, how did we go, in a transparent way and not sort of presenting motivated research, because I think that's when motivated research may as well just be an opinion, because
Yes.
it's actually not based on the evidence. Just write an opinion piece, So, but if you're going to go to the effort to collect data, do it in a way where there's evidentiary value to the data that you're collecting. And that comes about from using sort of open science methodology where you're committing to positions, sharing the data so other people can verify your analyses, committing to analysis plans so that, all those researcher degrees of freedom are controlled for. And, there's no kind of saying, oh, that's what I predicted all along, even though because the data didn't quite work out as you're expecting, So I think if we do that, that can help part of that sort of trust building and openness, when we're collaborating with people.
Almost like, allowing our fellow researchers and academics to be the jury of our
Pretty much
of our research, because that's the scientific method. It says we're open, we give all the evidence, we demonstrate our methodology, our statistical analyses, how we did it, because sometimes it's difficult and it's not going to be as robust because there are constraints, and that's fine. That goes in the discussion and how do we improve things, and maybe the next person can follow on from that, or if we get the next grant we can continue to do that, but it does mean that we're advancing our knowledge in that. One final item for you is, where can people find out more, about this topic? Obviously, this is something that you're extremely well read in, and you have lots of your own research, and where can people find out more? And there might be also some students that are eager to follow this as well. So how can they, maybe even reach out and get in touch?
So, if people just want to learn more about it, we talk about a lot of this research in the online course I mentioned before. So on the edX.com, I think it's not edX.org platform, sorry, you can search for a course called The Psychology of Criminal Justice. The course code is Crime 101X. So that's a course where we filmed fictional trial. It was a murder case, and we followed it all the way from the investigation through to the jury trial. And so we had actors play all the roles and had a film crew. We broke it up into 8 episodes. And so then we talk about what's going on in each of the episodes, and we relate the research to what's happening in the trial. So the profiling, the investigation, the interviews, there's confession. We talk about evidence at the trial, and then we get to see a jury deliberate and arrive at a verdict. So we talk about all of these. A lot of the things we've talked about today sort of come up in that course. So anyone can go on there and audit it if they want to. We also have sort of a more general psychology course where we talk about sort of social perception and biases more generally. That's on the same edX.org platform. That's the PSYC1030 X series. If you search for that under Introduction to Psychology.
And is that PSYC?
It is.
Without
yes.
a H?
Yeah, PSYC 1030.
That's what I got on my notes. I just want to make sure that's correct, because
and we cover a whole range of things in that course, but there's one particularly on social psychology, including sort of social perception and stereotypes. So we talk about a lot of those issues there as well. And then, I've got a webpage at the University of Queensland. If you sort of Google my name and put University of Queensland, it'll take you to my researcher profile, which will have links to some of the research I've been doing.
Fantastic. And what is your latest research? What are you doing at the moment?
Well, we're coming to, we're sort of in the third and final year of a large-scale project with a police service where we've been revisiting their training. And we've sort of been evaluating the effectiveness of some training packages we developed with them. And so that's the sort of hot topic research we've been doing at the moment, sort of applying what we know about misconceptions and stereotypes and also learning theory to try and make training more engaging and effective for people, and to help them sort of think, in a more evidence-based way and a more victim-centric way as well.
Really brilliant. Look, I can't thank you enough. I really appreciate your time and expertise, and appreciate the work that you do. I think this topic really needs and deserves a whole lot more attention from people like yourself who are clearly passionate about informing good practice. From all levels. From an unbiased perspective of saying how can we even just examine the architecture? How do we examine how the presentation of evidence is provided? How can a defence, be better? How can jurors be better informed? How can prosecutors be respectful of people? How can we be more human while also maintaining what the legal system is intending, and trying to do, with great effort. And so really appreciate your work and thank you for your time today. It's been, amazing for me. I've learned immensely. I have a whole lot of preconceived ideas about what the law is and how psychology plays. And the truth is, I know nothing. I'm definitely more informed after today. And I'm sure our listeners, will be as well. So thanks again, Blake.
Thanks very much. Appreciate the invitation.
If you enjoyed this podcast, please support it by going to iTunes and putting a review, subscribe, share it via social media, and tell others about it. Start a conversation. It's listeners like you that make this able and possible, and why we bring in these guests to go out and share their knowledge and resources. And just lastly, if you are a psychologist and you want to go out and be part of a bigger team, develop your experience and get into some exciting work, come to strategicpsychology.com.au/careers and reach out. I'd love to hear from you.